Chebukati's motion at the Supreme Court claims that the apex court appeared to contradict itself on the role of the chairman, and to avoid any errors before the fresh election is held, it needs to state clearly what it means in parts of the ruling specifying the role of the chairman. Chebukati in his petition wants the Supreme Court to determine which results between the tallies contained in the Forms 34B submitted by the returning officers to the tallying centre and the totals of Forms 34A as verified at polling stations and constituency tallying centres should be used to declare the results of the presidential election. He also wants the Supreme Court to make it clear whether, as the national returning officer, he can correct errors identified in Forms 34B and amend them where they differ with Forms 34A after the verification exercise. This confusion, he says in his petition, is because the Supreme Court in its ruling claimed that he had announced the winner of the August 8th presidential election without verifying the results that were coming from the polling stations and the constituency tallying centres.
The failure by the first respondent to verify the results in consultation with the second respondent before the latter declared them, therefore, went against the expectations of Article 138(3)(c) of the Constitution, just as the failure to electronically and simultaneously transmit the results from all the polling stations to the National Tallying Centre violated the provisions of Section 39(1)(c) of the Elections Act.
In the end, the Supreme Court may have to determine what exactly to verify means, because according to the Court of Appeal judgment that was read in June, the judges affirmed a High Court decision which had said that results once announced at the constituency tallying centre could not be varied, altered or changed unless through a court order.
It is, in our view, fallacious and flies in the face of the clear principles and values of the Constitution to claim that the chairperson of the appellant can alone at the National Tallying Centre or wherever purport to confirm, vary, or even verify the results arrived at through an open, transparent, and participatory process as we have already set out.
The Supreme Court judges had said as much when they read their own judgment last month.
What the second respondent was barred from doing by the Court of Appeal and by the High Court was to vary, alter, or change the results relayed to the National Tallying Centre from the polling stations and constituency tallying centres under the guise of verifying.
Chebukati says his application should be heard urgently in time for the October 26th fresh presidential election. Andrew Ochieng, NTV.